All right. So my name's Carl Fisher, and I'm a forensic psychiatrist. That means I work in the kind of psychiatry that deals with the court system, the kind of evidence people bring about neuroscience, mental health, psychiatric diagnosis, and the way that impacts the way we think about law. So today I wanted to talk about punishment, because one thing I've become interested in is there's a new trend of people actually using neuroscience itself, brain scans, brain images, in the court to make certain arguments about the way we punish individuals, or even about the way our legal system should function overall. And in its most simple form, this takes the shape, it wasn't me, it was my brain. So it sounds a little sketchy when you see it at first, right? It doesn't make total intuitive sense. If my brain is the thing that produces my mind, if that's where my experiences and my thoughts and all of my feelings and motivations are stored, then how could a reference to my brain mean that I'm not responsible for a crime that I commit? Let me tell you a story that might help to set the scene and understand some of the issues here. So this is a real story. It happened not too long ago in Virginia. There was a mild-mannered, middle-aged guy, early 40s, stable life, had a wife, kids, picket fence, and then all of a sudden he develops this interest, brand new, hides it at first, in child pornography. He starts collecting it, he starts secretly gathering it, and then it starts to get worse. He gets interested in massage parlors. He starts propositioning people for sex. And then eventually, sadly, his wife catches him making sexual advances toward his 12-year-old kid. So he's brought before court, and he's convicted of child molestation. And as a first-time offender, he gets the opportunity to engage in a treatment program. So he goes to treatment groups, he gets some sort of therapy. But he fails miserably because he can't stop propositioning the other people in the groups. So he's scheduled to go back to court, and this time he's getting sentenced. This time everyone knows that he's going to get some jail time. The night before the court, he goes to the emergency room, and he's complaining of the worst headache of his life. So once people get the full story, they think, hey, maybe he's trying to get out of his punishment. You know, this doesn't seem like it really hangs together. But they give the guy the benefit of the doubt, and they do a brain scan. And they find this. It's a huge tumor in his frontal lobe. Luckily for him, it's a benign tumor. It's actually just a bone tumor that's pressing on his orbitofrontal cortex, which is the part of the brain that people think governs social behavior and social regulation. So they remove the tumor. The guy does all right. He goes back to the treatment court, and he passes with flying colors. He's back to his normal, mild-mannered self. Then a couple years later, he starts to develop these urges again, but thankfully he's on the lookout for it. Goes back. Sure enough, the tumor is back. It's removed again, and he's fine. And as far as we know, to this day, no more problems. So my point here is that this notion, it wasn't me, it was my brain, sounds a little odd at first, but maybe there are certain cases where it actually makes sense. Maybe there are certain cases where we have to investigate a little further. So this is some research from some Duke University law researchers looking at court cases and how often they cite actual neuroscience, how often somebody produces brain imaging or brain scanning evidence. And so in 2005, we already had about 100 cases where people were doing this. This has grown exponentially, though. So in just 7 years, more than double the number of cases are being produced in court. So this is happening. It's already getting traction. And these are only the court cases that are reported in opinions. There's probably more going on in the everyday practice of courts. So in most cases, this has to do with mitigation. It has to do with lowering someone's sentence, not getting them off entirely. So let me give you a couple of examples about how this works. So in the United States, there is a famous case of a serial killer called Brian Dugan. And I won't get into the gruesome details, but the point is that there was no doubt about his guilt. It was very clear that this man was guilty. So the prosecution was going for the death penalty. The defense lawyers decided that their strategy would be, let's get an expert in brain imaging, scan his brain, and put up some cartoons to make a very novel argument. It was the first time it happened in American courts. And they argued that Mr. Dugan has psychopathy. Psychopathy is a special medical condition, as indicated by his brain scans. He can't engage in the normal sort of impulse regulation. He can't govern his behavior. There's just something wrong with his brain. It's not him. And it's always hard to say exactly what causes a particular event, what causes the jury to make a decision. But in this case, they actually avoided the death penalty. So for an even more stark example, let's go over to Italy, there was a woman, Albertani Stefani, just a couple of years ago, who killed her sister, attempted to murder her parents, and got a life sentence. But then the defense got the opportunity to present some more evidence, so they presented some evidence about brain imaging, and they made the argument that the brain areas that govern impulsivity were dysfunctional in her. So they managed to reduce her life sentence down to 20 years. So we're already seeing some evidence that this stuff is working. It's getting traction, it's being used, and in particular cases, brain imaging is actually managing to lower particular people's sentences. But does it have any impact on the court system at all? Can it change the way that we punish people overall? So to answer that question, I'm going to turn to the US juvenile justice system. So if you've had any familiarity or any encounters with this system, you know that the US can be pretty harsh when it comes to punishing kids. Until recently, kids could get the death penalty, they could be sentenced to life without parole. But there's been a series of recent Supreme Court cases that challenge that notion. The first was in 2005, Roper versus Simmons. And this was a case that challenged the death penalty for 16 and 17-year-olds. And the majority opinion ruled that that was unconstitutional, that you couldn't give the death penalty to juveniles. And it's an especially notable case because for the first time, the Supreme Court actually cited neuroscience data. They said not only are adolescents not fully mature, that brain imaging and brain scanning actually shows us that. They show that the brain is still developing and evolving at that age. And that's part of their justification for why this is unconstitutional. Moving ahead to more recent cases, two more cases just very recently challenged the possibility of life without parole for juveniles. Again, found unconstitutional, but what's notable is as we go in progression, case to case, the amount of the court opinion that's devoted to neuroscience is increasing. What was just a footnote in Roper versus Simmons is now a whole section in the most recent case of Miller versus Alabama. So we see that in the highest court of the US, there's more and more focus on neuroscience. It's getting more traction. So this has led some folks, especially in academia, to make some claims about how neuroscience should change the way we think about punishment overall, about how our punishment practices in the United States should be changed. So this is David Eagleman. He's a neuroscientist down at Baylor, and he's got a good example. He says that criminal activity should be taken as evidence of brain abnormality. We shouldn't see it as bad behavior. We should just see it as some sort of biological dysfunction. And furthermore, that we should tailor punishment to individuals. It should just be about rehabilitation. It should just be about treatment. This is becoming a very fashionable idea. Throughout all the halls of academia, philosophers, law professors, neuroscientists are now looking to neuroscience to provide the justification. Punishment in the United States right now, they say, is too retribution-based. We're trying to give people their just desserts. What we should be doing is be focusing on rehabilitation, about helping people. So it sounds like an attractive concept, right? To have a more humane, a more just punishment system. But I think we need to look to history for some lessons about how this might play out. So this is a picture of the Alcatraz Jazz Band in the 1950s. So back around this time, the 1950s and 60s, in US punishment philosophy and US punishment justifications, people were very invested in the rehabilitation model. There was a lot of focus on addressing the root causes of crime. Maybe if we can provide people with useful opportunities, ways to develop themselves as people, we can prevent crime. And once people are released, we won't get the same rates of recidivism as we do normally. Problem with this was that it didn't work. The social reformers were overclaiming, overpromising, and then when those results weren't realized, it set the stage for a backlash. So by the 1980s, we have a totally different rhetoric. We have the war on crime, mandatory minimum sentences, determinative sentences that take more of the choice out of judges' hands. What I like to suggest is that this is in large part due to a setup. The social reformers of the 50s and 60s, by overpromising, set the stage for this sort of backlash when the pendulum swung back toward a more retribution-based punishment system. This is a graph of incarceration rates in the United States as a function of population. So it's just the proportion of people who are locked up at any given time. So what we see here is dating back to 1925, incarceration rates were relatively stable, including through the social reform era. But then around this time, in the late 1970s, 1980s, where the tough on crime rhetoric starts to pick up speed, we see a massive increase in incarceration rates. And so to bring this back to neuroscience, the story I want to tell is that it has implications for what we do with the science that we're using. To promote a treatment model sounds good, but we have to be careful about what scientific arguments we hitch onto a policy argument. Neuroscience might have a limited role in the courtroom. In cases where someone has a tumor, in cases where someone has a clearly identified abnormality, it might be useful to investigate further. But even then, facts are just facts. And that's how science works. They give us the facts, but then in the court of law or in ethics or any sort of value system, then we have to make the active step of making a determination about what actually matters. I'd like to suggest that the dangerous part of this trend is this notion. It isn't us, it's our brains. To argue for a system-wide reform on the basis of neuroscience gets into dangerous territory. We've already seen that making over-promises and making over-claims might set the stage for a pendular backlash. And you can imagine the same sort of data being used for the opposite argument. If someone's brain is broken, or if their brain determines that they're a criminal, why not lock them up for longer? So I think we have to be careful about these questions. There are a lot of questions that are worth asking about the US punishment system. My point is not to make a political point, but just that whether we're interested in whether the US legal system is punishing people the right way, if our penal system is accomplishing the goals that it set out to accomplish, these are questions worth asking. But we don't need to wait for neuroscience to tell us the answers. We don't need to hitch our arguments onto neuroscience. That's my talk. Thanks very much.